Hello, this is Matt on the Moon Lambo channel, and it's official. The SEC has now made it publicly known that they intend to complain, let's say, I'm going to choose the word complain, to Judge Torres about Judge Knepper's decision, which came out a week and a half or so ago, whenever it was, pertaining to the SEC's assertion that they had attorney-client privilege regarding Bill Hinman. And as a result of this attorney-client privilege, any of the emails surrounding the Ethereum free pass speech from Bill Hinman in June 2014, any drafts of speech, any of that, should not be part of the case, cannot be part of the case, they argued anyway, because that would go beyond the barrier of attorney-client privilege, which is ridiculous for a number of reasons. I've always thought it silly that they'd actually claim that Bill Hinman is a client of the organization that actually employs him, but setting that aside, we already know that Judge Knepper came out with her most scathing comments against the SEC in the history of this case. And literally saying that they were behaving in a hypocritical fashion, and stating that she didn't believe, Judge Sarah doesn't believe, that they were operating in good faith in terms of application of the law. Scathing stuff. And of course, having followed the case for over a year and a half now, I could not agree more. I've been observing this behavior from them consistently. It was so nice to see Judge Sarah Knepper say something on that front. Well, yesterday, SEC filed their request to submit some specific drafts, and I'll get into the specifics of the details in just a moment here. And today, we did get a ruling from Judge Torres on that, so I'm going to share with you that, as well as what Ripple had to say. And unfortunately, the SEC is largely going to get what they want, but on the plus column here, on the plus side of things, it's not going to go well for them. It's going to be real bad. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And I've got comments, by the way, from several attorneys within this video. First and foremost, shout out and credit to James K. File, an attorney within the XRP community, who has been breaking all of this news. And he said the following. The SEC has requested permission to file a 30-page opening brief and a 10-page reply brief in support of the SEC's objections to Magistrate Judge Knepper's ruling ordering the SEC to disclose the Hinman speech documents. Ripple objects. And so basically the SEC's making a specific request in terms of the quantity of information they can file on this topic of what Judge Sarah Knepper already ruled on, the attorney-client privilege stuff. What's at the heart of that, of course, is those Hinman emails, the documents surrounding his Ethereum free pass speech, which we know there's gotta be, right? Don't you think, speculating fine, but don't you think there's something exculpatory in there that would just absolutely devastate the SEC's case, given that they're going to these extremes? And it is not a good look when you have the judge before the trial even start say, this is hypocrisy and we don't think that you're operating in good faith according to the rule of law. But still they're pushing further. They're going to push forward with it. This is absolute insanity. And I'm not going to read the actual filing from yesterday from the SEC. It's on your screen, but I think I sufficiently summarized it. If you want the exact words, hit pause, but otherwise I'm moving forward here. But I think Attorney Jeremy Hogan really hit the nail on the head, expressing just how absurd it is that the SEC is actually pushing for this. And so here's what Attorney Jeremy Hogan had to say in response to this. The SEC is actually going to object to Judge Knepper's scathing order regarding attorney-client privilege and ask Judge Torres to overturn the order. And this is the order in which Judge Knepper called the SEC's argument hypocritical. Someone needs to talk them off the ledge. He's so right, though. Someone needs to talk them off the ledge. I'll tell you what, I just let them walk off. I'm not going to stop them. They can hang themselves, whatever. It doesn't matter. See, and that's why I keep saying that there has to be something so severe, because how could they possibly think, a couple things, that this would work and that it could possibly, strengthen their case in any sort of way? Even if they because I think they know that Judge Torres isn't going to approve. Like, Judge Torres is going to side with Judge Knepper. Like, do they actually think that there's going to be any net plus as a result of this process? And that's why, to me, it just looks like a last-ditch effort. And at some point, they're going to have to actually recognize that, no, we got to turn over these documents. And at that point, I don't think that they will. I think what will happen at that point is that they're going to come back to the table and there will be settlement talks with Ripple. They're never going to hand these over. That's my prediction anyway. We'll see if I'm wrong. Great, because I'd love to see what's in them. I don't think they're going to see the light of day, though. Perfectly honest with you. And then there was Attorney Bill, a member of the XRP community, who retweeted what I just shared with you from Attorney Hogan and wrote the following. He said, "I got that one wrong. I did a thread on why the SEC's position on an objection to the attorney-client privilege decision was hopeless, and that it would limit the objection to the DPP decisions to the back of the class for me." So what he's saying there is, Attorney Bill thought that if the SEC was going to come push back in any degree and go cry to Judge Torres, then it wouldn't be about specifically attorney-client privilege, it would be about deliberative process privilege, which is what DPP stands for. Because you may recall that what got us to this point even was that back in January, Judge Neprin said, hey, you got to hand over these emails. And then they pushed back, and then there was another ruling in April and said, no, you got to hand these emails over. So then they made a whole new assertion. Okay, now it's attorney-client privilege, and then she's still like, super duper duper, you really have to hand these emails over. And the attorney-client privilege claims were so weak that what Attorney Bill is saying is, if they're going to push back and cry to Judge Torres, which he did think was probable, certainly, that they not talk about attorney-client privilege stuff. They'd be talking about DPP, the privilege claim. And he's saying, well, got that one wrong. But see, and that's not to critique Attorney Bill. And he's not the only one that thought that, by the way. It's more like the SEC is that insane. Bill's great. So please nobody take that the wrong way. I think Bill's fantastic. I always appreciate his insight. And actually, Attorney Hogan agreed with Bill. Check this out. In response to that, Attorney Hogan said, I agreed with you. I thought they would limit the objections to the DPP issues. It's the smarter play. Yeah, smarter play, but what are they? They're arrogant asshats. They're so arrogant, so pretentious, they think they can do whatever the hell they want. And then Attorney Bill responded to Jeremy and said, it really does seem that delay is the end goal and the outcome doesn't matter. Does kind of look like that, doesn't it? Now, here's what Attorney Deaton had to say in response to Bill saying, I got that one wrong. Attorney Deaton says, no, you're still in the front. The SEC lawyers live in the tightest of echo chambers and are so arrogant, they honestly convince themselves they have done everything proper and Judge Neprin is wrong. I guarantee you, they say she failed to understand the nuances of their positions. Yeah, and by the way, so I'll just pause now. We should, whatever they file, we should have access to that so far as I understand, and I won't be surprised if it's something to that effect. However they word it. Judge Neprin, she really didn't understand, didn't comprehend the argument. They'll finesse it as much as they can. But still, like, what Attorney Deaton's saying here is in line with one of the messages I've been delivering for the longest damn time. Like, these really, truly are arrogant people. They think they can do no wrong and they can get away with anything, and a lot of times they do because they're the bullies. And that's why there's 95% settlement when it comes to charges to SEC claims. It's like people just don't have the mental fortitude, and I understand, to fight them. And it's not always just that. Even if you've got the emotional strength, do you have the funds necessary to wage a multi-year campaign against the SEC when they're bullying you? And for most, the answer is no. But thankfully here, with Ripple, the answer is yes. And I am thankful for that. That's for damn sure. And then there was also this from an XRP community member named Yasin who wrote, it's clear to me the SEC cares more about delaying the outcome of the Ripple case than the outcome itself. That's why they're attacking crypto on multiple fronts, Library, Coinbase, other tokens, etc. They don't want a loss against Ripple before they can score a win somewhere else. Let me pause here. So a couple of things on this here. I'll just tell you my unprofessional opinion since I'm not a lawyer here. So a lot of this looks like delay tactics. I think that most of us would probably think, yeah, it seems pretty damn clear that there's delay here. But do they care more about delay than the outcome of the Ripple case itself? My bet would be that they care about the outcome more because this is going to have major impacts moving forward. It's going to be precedent setting. So either the SEC will end up with more power or less power. So my bet would be that they do care about it more. But either way, they're still going ahead with the delay tactics, that's for sure. And then Jeremy Hogan responded to that idea and wrote, it's possible, but after watching the Ripple litigation unfold, I'm not sure the SEC is this forward-thinking, to be honest. So fair enough. So then we got some more news today here, and this is shared also by attorney James K. Filan. Ripple responded today with their response noting that it's, I don't want to read the whole thing. So here, there's 2 pages. So pause here. Here's the first one if you want to read it. And then I'm going to flip over right now to the second page. And you can pause that too if you would like to read it. But just to kind of sum this up, one of the things that Ripple, their attorneys were arguing against is that basically the SEC is requesting to provide twice the usual number of pages in support of its objection. And they also went on to state that it doesn't even make sense because, you know, they haven't even seen Ripple's response to any of it. Like, why are they asking for twice what they would normally be allowed? It just seems, at a minimum, premature, they wrote, you know. And so upon seeing that, Judge Torres took it all into consideration, and she shared the following. It's actually, so this is the document from yesterday, and she added this, so it's in the bottom left. This is actual text from Judge Torres in response to the letter from yesterday from the SEC, and this is what happened late this afternoon when Judge Torres had her say on this. And she didn't explain, like, you know, exactly what the thought process was. She just made an order, effectively, and she wrote the following. Granted in part, denied in part. The SEC may file a 20-page opening brief and a 10-page reply brief, so ordered. So there you go. Judge Torres says, yep, go ahead and file stuff. Those are the page requirements. So it's still, you know, more than what Ripple wanted them to be able to file in terms of quantity of pages, and it seems premature to them. Okay, fine. But they're going to do it. And you know, Judge Torres, it's not like she doesn't talk to Judge Netburn. I think it's reasonable to speculate they feel very similar on this topic, and still the SEC is going forward, and they're just gonna be hanging themselves. It's completely ridiculous. Oh, it's gonna be a good time. I can't wait to see it. I'm going to enjoy making a YouTube Moon Lambo hot jam about that topic. That's gonna be a lot of fun. But wow, the arrogance of these people. How pretentious must one be in order to think that this makes sense? They really do. That's why, again, that was my favorite line. I'm probably going to put it in the subject title of my video here. Is Eric B. Hogan, the quote from him, someone needs to talk them off the ledge. No, nobody talk them off the ledge. Let them do what they're doing. Just let them do what they're doing. It's perfectly fine so far as I'm concerned. Oh, what a crazy ride. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.